On Citizenship and Immigration, meeting number 62. This meeting is televised. We're studying Bill C-43, which is an act to amend the Immigration Refugee Protection Act. We have Mr. Curlin, Richard Curlin, who is the policy analyst and lawyer who has been here many times. And we have Ahmed Hussen, who is the national president of the Canadian Somali Congress. Mr. Curlin, we'll let you go first, sir.
Well, today, buckle up, it might be a bumpy ride. This is unusually complex in terms of subject matter. The appropriate direction has been taken to remove, swiftly, foreign criminals from Canada. No doubt about that. The concerns I raise only pertain to two topics. One, I must take a pause. Much of the affected inventory of people will be comprised of long-term residents of this country. People who arrived at a tender age, 2, 3, 4, 5 years old. And what I'm recommending for consideration is not with this particular bill before us, but in connection with citizenship. I see no reason why we cannot provide a grant of citizenship to individuals who have been living in Canada 10 years prior to their 18th birthday. This would capture the long-term legal residents of Canada who, for whatever particular reason, run afoul our criminal justice laws. And this would redirect criticism away from the point that, in effect, we are implementing a sense of medieval law, the law of banishment. So that would be the first point. And the second relates to retroactivity. Now, I assume properly that this proposed bill will not have retroactive effect. And the very purpose of law is to allow the individual to govern their behavior. Imposing with retroactive effect the penalty of removal from Canada is incompatible with some of the tenets of our criminal justice system. The sentencing judge did not have the opportunity at the time of sentencing to deal with the individuals. And so, ironically, rather than expedite the removal of criminals from Canada, it may well retard that effort given the legal issues that are raised by the issue of retroactivity. I also note that if it were an assumption that the retroactive application were to fall into place, we would have heard from affected groups and individuals. Witnesses would have been called upon to testify on the results of retroactive application. So I'm hoping that our judiciary, if when they review the transcripts of this standing committee, will note that retroactivity may or may not have been on the table. As far as I'm concerned, it's not on the table. Having said that, I like clarity, transparency, and expeditious treatment. I'll close my opening remarks with this observation. Over the 20 years or so that I've had the privilege and honor of appearing before this committee, I've noticed the trend of heightened requirement of sainthood over time when it comes to selection, when it comes to removals. And I remember the rancor at each occasion when the triggering of loss of appeal is discussed. 5 years to 2 years, and now 6 months. Well, is there something in logic? Is there something rational that you can palpate to connect the dots? Why we have continually gone down the time chain to where we are now. It's the very function of our parliamentary democracy to reflect the will of Canadians from coast to coast to coast. And what is occurring in this legislation is the expression of the will of Canadians from coast to coast to coast. I have taken criticism personally and professionally for not doing more to combat the lowering of the threshold from 2 years to 6 months. But I would have to be in a disagreement, and I am not. I believe that, big picture, we are appropriately downloading to the criminal justice system the quality of mercy and the immigration situation of the particular individual, because it is the role of the sentencing judge in a criminal court to look at the specific case and to make a decision that will affect the life of the person before him. It should not belong to the immigration system. It should be properly put in the criminal justice system. That also will address the regional variations in what people want. So the big picture, I think we're doing the right thing here in terms of design. I have a problem with citizenship, which is going to affect a large component of the affected group by these changes, and I am dead set against the retroactive application of this legislation on several levels. Thank you.
Thank you, Mr. Curlin. You always give us food for thought. Mr. Hussen, you have up to 10 minutes, sir.
Yes, thank you, Mr. Chair, and thank you, members of Parliament, for inviting me. My name is Ahmed Hussen. I'm the National President of the Canadian Somali Congress and a lawyer by profession. I'm here to talk about the bill. In principle, I want to get on the record that the vast majority of my community, as well as other Canadians, do believe in the principle that we should deport foreigners who commit serious crimes. That's not in debate. The issue is implementation and who this proposed legislation would capture. In its current form, the bill would disproportionately punish law-abiding, long-term permanent residents that make one small mistake, because this bill would limit the right to review for cases exceeding 6 months. This is a point that's really important, because you can have a situation where someone didn't take citizenship for whatever reason, but is otherwise a very long-term resident, contributing to the success and prosperity of Canada. And because of one mistake behind the wheel or otherwise, finding themselves in the situation where they're about to be deported.
So, sir, we have bells ringing.
Yeah.
Do we have unanimous consent to allow Mr. Hussen to continue? We will have to leave, sir, because there's going to be votes in half an hour. Do I have unanimous consent to allow Mr. Hussen to finish his remarks?
So we have a few suggestions to make in terms of keeping the bill's principle alive, which is deporting foreign criminals who are serious criminals and a threat to this country and this society. However, making a few changes that will reflect the disproportionality of some of the options. One, we should definitely make an exception between conditional sentences and jail. In its current form, the bill does not do that. So you can have a situation where a permanent resident facing jail time may be sentenced by a judge in the community's interest to conditional sentences due to the fact that that person is gainfully employed. But because of the nature of conditional sentences take longer to fulfill by their very nature. But ironically, that would actually lead to the capture of this person with this legislation, because it would exceed 6 months. We strongly urge that an exception should be made in this legislation between conditional sentences for first-time offenders and people who are facing jail time more than 6 months. A permanent resident who is given a conditional sentence in order to keep their job is a plus for Canada. And because of that positive approach by a judge, that should not lead to them losing their job and being deported because they opted for a conditional sentence. Otherwise, you would have a situation where permanent residents would opt for a jail term, lose their jobs, or drop out of university for a jail term, opt for a jail term of less than 6 months, and opt out of a conditional sentence availability so that they can avoid deportation. And then when they come out, they're out of a job or dropping out of school. The second point that we urge is that ministerial discretion in humanitarian and compassionate ground cases should not be curbed. Ministerial discretion is there for a particular purpose. It's there in these cases when the law on its face cannot capture some of the unique cases that should be captured. What springs to my mind is the case, for example, of the South African family who were in BC, whose child could only live in a place like British Columbia because they couldn't be exposed to direct sunlight. That's something that the law doesn't capture, and it's where we expect the minister to use his discretion in those kinds of cases.
Was the witness just saying we don't have direct sunlight in British Columbia?
For the most part. Serious criminals should definitely be deported, but not well-established permanent residents who make one silly or minor mistake. Last but not least, we should, if we're going to capture thousands of more people who, again, are captured by this proposed legislation, we have no problem with that, but we also urge that we should then, as a country, take in the extra responsibility of helping those countries that these people will be sent to enforce and strengthen their law enforcement capabilities, because I, for one, know of few individuals who deserve to be deported, who are serious criminals, foreign nationals from Somalia, who were sent back to Somalia, but the local authorities could not handle this influx of serious criminals, not just from Canada, but from the UK, Finland, Sweden, and so on. So we can make a token donation to make sure that those societies can cope with this, with what I expect will be an influx of a lot of people coming in. Thank you very much.
Okay, we are going to adjourn, or suspend rather, because we have to go and vote. The chairman's inclination is, if these, are you available to come back? Because we probably won't get back here till 4:30. Are the two of you available to come back at 4:30?
Yes.
Yes. Okay. Then I'm going to unilaterally say that the minister will have to come another day. This meeting is suspended.